page 57. And James, that's over to you, is it?
Yep. Thank you, Chair. So I'd like to address this paper in two parts. First of all, with respect to the proposed review, and then secondly, with respect to further direction to HBRC by way of their statement of intent. So with respect to the first issue, the proposed review, as councillors will appreciate, there are a large number of issues related to the councils and the communities and the region's interests in the proposed Ruataniwha water storage scheme. These are of, as the paper notes, commercial, economic, social and environmental. And as councillors will be aware, there have been multiple legal proceedings, including the Board of Inquiry itself, that considered a vast volume of evidence and spent some months considering all of that. So when we think about a review, there is a scalability question really in terms of how large this undertaking is and how much of the material that has previously been considered and traversed by various courts and by this council in previous trienniums, how much of that needs to be reconsidered, if you like. So it hasn't been possible prior to today to definitively determine what are all of the matters that may wish to be considered, what are the resourcing implications of considering those, and what's the timetable around it. However, based on the issues that were identified during the council workshop last week, week before last on the 26th, we have done a preliminary review of what that's likely to look like and what it's likely to entail. And our initial view is that we could have completed the preparation of advice to council by the end of February next year for consideration in March next year. I do just want to stress the fact that it's a preliminary view. We do need to continue to talk to councillors about the specific areas of focus, and obviously the more general the review is and the more matters it covers, the longer it will take, the more it will cost, and the more displacement effect it may have on existing work programs. So therefore, the more specific we can get about those matters, the more expeditious this exercise will be. So it's proposed that we will come back to councillors at your meeting at the end of the month on the 30th with more definitive advice about precisely what the matters for review will include and what the resource implications are of those, including what external advice you may believe that we may need to seek. There are a range of external advisors that have provided advice to council to date, and Deloitte being one example. And of course, given the investment to date, they are well positioned to provide advice, further advice relatively simply. If we were to go to a whole new provider, the cost of that exercise would grow significantly, and we would therefore need to start from scratch with a new group of advisors that know potentially nothing about the scheme. So that's something to weigh up on the 30th. So the intent is to come back to you at that point, and what I propose is to have discussion with those councillors who have a particular interest in the scope of that review prior to the finalisation of that paper for the 30th, so that we do present a paper that meets expectations. The second matter to comment on...
Mr. Chairman, before you go off that, I would expect that all 9 councillors in this room have an interest, and a particular interest in the review.
So, Councillor, if indeed all 9 councillors wish to provide input into the scope of that review, then that would be very welcome. We just need to arrange a mechanism to do that, because I appreciate that for councillors there are some timing imperatives here, and to have a further discussion about the matters for inclusion in the review on the 30th will only delay getting the work commissioned. So it may be that we can have a workshop, or that we can do it bilaterally with each of you by way of email correspondence or something like that. Perhaps that's something you might like to discuss amongst yourselves this afternoon, about what's the most effective mechanism to provide that feedback to me in particular. So just moving to the question of further direction to HBRC, the paper does set out the process under the Local Government Act for making amendments to the Statement of Intent, and indeed you are quite entitled by way of resolution of Council to make amendments to the Statement of Intent. I would draw your attention to the requirement in the Act for the Council to consult the Board of Directors on that direction. And I'd also just draw your attention to the fact that there is a good body of case law around what constitutes consultation. It has been litigated to death, that question, by many aggrieved parties over the years about consultation being not genuine. And the case law around that does require a good faith attempt at dialogue backwards and forwards. So if there is a proposal by way of amendment to the Statement of Intent, then staff advice would be that you'd need to make that proposal known in specific terms to the board and take on board the board's feedback, show that you've given due consideration to that before making your final decision. So I'm merely just reflecting on what the case law has said on that matter to date. It's proposed that following today's discussion that councillors may wish to seek some expert legal advice on the matters arising from potentially issuing further direction by way of modification of the Statement of Intent. And I would perhaps suggest also that there would be value in, during that period, also consulting the other key partners in the scheme, particularly Crown Irrigation and the institutional co-investor, to ascertain their views of any further direction and what that may mean to their interests, as those parties are also obviously deeply engaged in the scheme process and have made investments and commitments to date. So the proposal is that advice could be brought back potentially on the 30th or to the first meeting of the Corporate and Strategic Committee. The Corporate and Strategic Subcommittee terms of reference was signed off earlier during this meeting and covers the investment interests of Council, including our economic development activities, so it is the appropriate committee for that advice to go back to. Thank you, Chair.
Thank you. Any slowdown in this Ruataniwha Dam project at this point in time is hugely distressing for the project at large and in particular for my community. So my question to you, I think maybe I'm not sure who I'll put it to, you can think about who answers it. All of you is, how can we speed up this review? Because I understand that there are a number of new councillors around the table and we've got a lot of information under our belts that we have assimilated over the years, but people do need time to catch up and maybe refresh. But how can we speed it up? Because you're asking for a cup of tea, but a cup of tea is 10 minutes. It's not 5 months. I don't see a need to send unrest to the community, to the water user contracted farming community who are sitting, waiting, the investor who's waiting. We do have an enforced period where we're stopping here at the moment with the Supreme Court action, but can we not be sending a far clearer message to our community in a far more timely manner than sitting around and not having anything kind of coming back to Council sometime in March next year? This is just, it's very unsatisfactory.
Councillor, I'll give a response first and perhaps ask HBRC to make some comment as well. In terms of the process being run by council staff, the timing driver, as I said earlier on, will be principally determined by the scope of the review. And at the moment we have a reasonably long list of issues that relate to commercial prospects, they relate to wider economic benefits, they relate to environmental issues and they consenting issues, and they also relate to implications around Plan Change 6. So it is a reasonably broad review, and what I've said already is that our view, based on what we've seen, is that is 4 to 5 months' work. If there is a narrowing of the scope of that, then potentially it could be brought to a shorter duration. Of course, the challenge we have with that is the Christmas period. So we really want to work with you on that scope to determine how long it's going to take. And it may be that on the 30th, that there are packages of work that you may decide are of lesser importance and you're prepared to sacrifice in the interests of time. Until we can give you the detail of what those packages of work look like, how long they'll take, it's very hard to calibrate on that. I would just make the final point in passing to HBRC is that one of the other timing considerations for this obviously is whether or not there is progress that is able to be made in this with the scheme with respect to the outstanding land swap legal issues. And if indeed we are in a legal process that has say 6 months or 9 months to run, then that does provide us with a bit more breathing space with respect to the timing of the review.
Okay, because it's important we're not relitigating this whole process. This has been litigated throughout, well, my term anyway, and it's important to realise also that we consulted with the community in 2014 on this project. So, for instance, in my neck of the woods, they were well aware that they had to make an uptake of 40 million cubic metres of water. Well, that's sitting at 45.6, and now we have the chair turning
Point of order,
up.
Mr Chair. Just point of order. It appears to me that we're in debate as opposed to questions. Can we?
No, I'm quite happy to take her comments.
I'm moving to a question. Thank you.
It doesn't matter if you're not, or you can say what you like.
Thank you. So we've got the community who were told we've got this contractual water target to meet. We've met it, and now we've got the new chairman coming into meetings in the community saying, well, if you were sitting at 60 million cubic metres, we wouldn't have a problem. But I think, you know, the litigation of this process, I don't think that's the point of this review. So I'd like to clarify that we're not relitigating this. We're catching up, but we're not relitigating.
Yeah, can I suggest that those might be matters for discussion on the 30th when there is some specificity about what the review may or may not contain, and that the councillor may wish to make representations in relation to that scope and whether or not the matters are required or appropriate at that point.
All right, well, one final question. It is a question. What are the implications, Andy, of councillors pushing too hard and then becoming deemed directors in this process?
Council and councillors need to take their own advice about that. I'm certainly not going to give you any advice whatsoever.
Thank you, Chair. Yes, I've got a couple of questions. The first one's to you, Andrew. You are seen as the person who's the main front person for an advocate for this dam in your previous position as Chief Executive of HBRC. So, in my mind, if this review is to have any validity, it has to be done independently and objectively away from you. And I've counselled you on that 2 or 3 times already. So I was quite disappointed to see in the paper that's in front of us that you've approved it. I think, and I've advised you of this, you have to step away from the process. So I'm asking you to tell us how we can have confidence that this process is going to be run independently and that you're not going to have your handle over it, because the public aren't going to have confidence, and neither is this council, if you continue to do that.
So, Councillor Bevan, it's quite clear in that paper that James Palmer is the staff member charged with leading this review on your behalf, and I'm perfectly happy for James to be the point person for councillor interaction on it without me being in the middle of it.
So you're quite happy that he reports
Absolutely.
to us independently of you, and the paper doesn't have to go through you, because this one clearly has.
Oh, and it's a standard process that the CEO's name is on papers. But if that's a point of perception, I'm perfectly relaxed about that being the case. So the point being is that James is delegated to be the person who leads this review from the staff end, and he's quite entitled under that circumstance in my tenure as CEO to have direct contact with you without me being in the middle of it. Okay, is that clear enough?
Do you have a second question?
Yes, I do.
Come to you, Neil.
So this is directed to the board of HBRC. You're aware, of course, that part of what we'll be considering is a moratorium on expenditure, and I guess it comes in 3 pieces. There's the expenditure on the court case, there's the expenditure on the dam, and there's the expenditure on the compulsory acquisition of land. And Danielle's spoken on one. In response to you, Danielle, I'm interested in getting some gauge on whether the investment or the further investment we make in this court case is money well spent. That means we need to have a decent prospect of winning the appeal. Otherwise, why are we bothering to do it? So I'm interested in getting some legal advice on whether we've got some chance of winning in this, or whether the chances of winning in the Supreme Court are quite low. And I'm wondering, James, whether we wouldn't be able to get that advice to us by the 30th. I would have thought that would be possible.
I'm sure we can, so we will
So that's
attempt to do so.
All right, so I'm interested in the comments from the HBRC board on the other two matters. If we applied a moratorium on further expenditure on the dam, are there some forward commitments or something that you have made that we're not aware of, that we need to be aware of in considering that matter?
So there are, excuse me, there are probably some matters that it's not appropriate for us to talk to you about in a public forum, because they might be, they might affect the interests of other parties. So we need to find a way to talk to you about those. You asked a question about the requiring authority application. As far as we know, that is sitting in the Ministry for the Environment and going through whatever process the Ministry for the Environment go through. We don't anticipate any significant amount, and perhaps no further expenditure by us on that. There's a broader question, which again would be better to discuss in detail with you in a kind of workshop forum, about the implications of a moratorium and what does a moratorium mean. Does a moratorium mean no decisions? Well, if it means no decisions, that can mean no decisions to do things, and it can also mean no decisions to stop doing things that are already being done. So I think you need to be very clear about what you mean by a moratorium, and that's something that you may well want to give consideration to in your whole process of this review, and whatever consideration you want to make about our statement of intent.
Yes, so we can't make a sensible decision about that until we know what your current forward commitments might look like, and that's why I've raised this question. So if we just turn to the business of the compulsory acquisition of the land, what I'm hearing you say, I think, is that there's no further expenditure likely in that matter?
My understanding is none anticipated yet.
Yeah, okay, because, I mean, I've got some real problems with this, and it's something that's never been discussed with us by you. Here we are, an environmental organisation whose primary purpose is managing the environment, and we're proposing, if we lose a court case, to take conservation estate land by compulsory acquisition. And I'm sure there are a number of people sitting around this table who have got some fundamental, in principle, objections to that process. So if we came to you either today or on the 30th and said, actually, we don't want to pursue that at all, what would your response be?
I think our response would be that we would need to consider your proposition, similarly to Mr. Palmer's discussion about the legal advice that you would need to take about giving us a direction through our statement of intent. We would need to consider the implications of that. We would need to provide that information to you in a proper fashion. There would need to be a proper process to go through in all of that for you and us to have a sound legal basis for both you providing that direction and for us accepting it. And there probably would be some matters that would be difficult for us.
Mr. Chair, I'd just like to foreshadow an amendment to recommendation 2 in the paper, but to ask, it's really an aid of the concerns both from Mr. Palmer and Councillor Hewitt about timing, etc., and to narrow the range and gauge of the review. So to be helpful in that regard, I'm proposing that the word commercial be amended to read contractual, legal and financial implications. I say that because the word commercial has a broad connotation, and if we can narrow it down, we had some legal issues that we need to consider. There are clearly some financials that we need to look at, and contractual. And the other thing, Mr. Chair, is I'm hoping to add to the recommendation a review of the cost implications for withdrawal from the scheme. And I just wonder whether Mr. Palmer might comment on the implications of those foreshadowed amendments.
Excuse me, Mr. Chair, could I just clarify, Councillor, is that an additional recommendation or an addition to number 2?
It's an addition to number 2.
Thank you.
As a part of the
Can we,
review.
I think those are very good points. Can we just hold them until we've had a general discussion and we come back to these points?
Well, I was seeking some clarity from the staff as to the implications of a foreshadowed.
Yeah.
Chair, if I may, the intention certainly had been for the review to provide a picture to Council of the implications of withdrawal that would include all of those costs. So that's absolutely.
And the word commercial in its broader context.
Indeed, and no problem in changing commercial to contractual, legal and financial.
Okay.
Sorry, Chair, could I just seek a point of clarification from Councillor Curtin on what he means by that? Because one of the fundamental things that I think we need to look at, in light of the fact that the cost of the dam has gone from $250 million odd 2 years ago to 345 today, and only 45 million cubic metres have been sold. One of the things we have to have a look at is what's the deal mean for us in terms of some sort of commercial return on our money. Is that covered in what you mean by contractual?
Well, you could add viability to that, but that's a big. I mean, what I'm saying is commercial gives us how big is a piece of string. What I'm saying is there are some legal issues, some contractual issues. There are clearly some financials, and whether that includes the notion of viability, perhaps that could be incorporated into that aspect.
Well, I think that needs to be part of what we're looking at, whatever the words are that we use.
I've got a couple of questions. Yes, I do. I'd just like you to pick up on a couple of things here. I've got 4 points. Peter's covered on one of them was about the compulsory acquisition. Just to clarify, you said there's no further expenditure on this. Doesn't mean to say there's no further work being done on that. So I'd just like to clarify, what are we doing with are we doing in regard to progressing the option of using the Public Works Act for compulsory acquisition, whether it's expenditure or just work-wise?
Yes, we've made the application. The application's with the Ministry for the Environment, and that's where the matter stands. Until such time as they've made a ruling on the application, there is no action that we can take, and there is, at this stage, not anticipated to be any more expenditure unless they come back seeking more clarity on some items.
Well, you can do a lot of work on things without expenditure, and this leads me to the next one. What engagement?
I don't think we have any free labour, Councillor Barker.
Well, I've seen people pick up the phone and make phone calls and get things happen. Doesn't require a lot of cost, but it can have enormous effect. And on that vein, I just wonder what contact HBRC has had with government agencies, government departments and ministers on this issue.
I guess the same answer as before. We filed our application. It's sitting in process inside the Ministry for the Environment, and we have not had any significant contact with anybody since the application was filed.
Okay. My next question is, given that there's the court action and the prospect of a a pause while people re-look at this issue. What effect, if any, is that going to have on your relationship with the contractor and their readiness, willingness and ability to undertake the work, should that be the case? And along with that, there has been talk of an investor, not been named by HBRC, but what is the current situation with respect to the investor as yet to be unveiled by you, but known by everybody?
Again, I think I've given you the answer to both those questions earlier on. That both parties have indicated to us in writing that they are committed to the project and they are waiting until the land exchange matter has been resolved.
In the interim, has HBRC had any other discussions about another potential investor or investors?
Not with any, no.
Okay. The final question I'd like you to answer is that, look, you've spoken about the, should the council pass a resolution saying it's opposed to using the Public Works Act and direct acquisition, this would create some issues, or you would have to think very carefully about this. But I'd like you to reflect on your answer, given that quite a number of companies around the world and investors make decisions about ethical investments. Shareholders make decisions about ethical investments and say, for example, we don't want our organisation or entity investing into anything which has to do with the nuclear arms industry, with respect to tobacco products and tobacco, and no one sees a problem with that. So if there can be ethical decisions taken about tobacco, nuclear arms, just to go on a number of them, why couldn't there be an ethical decision about the use or not of the Public Works Act?
Point of order, Mr. Chairman. I think that question's been answered, actually.
I'll answer it anyway, Chairman.
Well, I don't think it has been answered.
It's entirely a matter for council to decide what you wish to instruct us about. What I've said is that some decisions that you might make might place us in a difficult position, and one of those difficult positions would be if your instruction to us turned out to be in conflict with our directors' duties to act in good faith in the best interests of the company. It's a matter that you might need to consider when you make such a decision. Other than that, you are the shareholders of this company. It is entirely in your prerogative to decide what you wish us to do or not to do. At the moment, we have a statement of intent that asks us to do 4 things in relation to this project. We have done those 4 things. We have done nothing but those 4 things in relation to this project. We will continue to do those things in relation to this project while we have our current statement of intent. If you decide to change it, there may be some implications, and we would like to have a proper discussion with you, not the Spanish Inquisition, about those implications.
Just before we... there are 2 issues here, and Councillor Wilson, and one was we're in a court case supporting DOC in the court case. There's that issue, and it was pointed out to us that that would have major effects on the whole process if we pulled out of that, and Council hasn't even discussed whether we pull out of that or not. The other issue is if we lose the court case and with DOC and us, would we pursue the other line, which I wasn't aware we had a application in, of using the Public Works Act? And I am on record saying I would never support that. I would never. So be very clear about that. So if that has implications, we're in a court case at the moment, and perhaps that's fine. Perhaps we need to see where that falls. But the other one is lifting the level up, another level, which I personally would struggle with. Councillor Hewitt.
Thanks, Chair. Andrew, question for you. I'm pretty keen to be part of a constructive council, not a destructive council. So can you please outline the implications if Ruataniwha is shelved? What will the implications for the Narora water storage be?
I suggest, Councillor Hewitt, you raised that question in relation to the terms of reference for the review and any other implications, broader implications, I think, and directed to James for the moment. I think that's the
Appreciate the question. Is there any more relevant questions? Thank you, Councillor Bell.
On this compulsory business and the meaning of a moratorium, it seems clear from the tenor of the exchange and the responses from Andy that no sort of sense of the conversation will be adequate, that if there is a will on the part of a majority of councillors to say we do not wish to pursue a compulsory taking of this land, we will need to make that as an instruction, which they will need to respond to, because they clearly are not inclined to take a read of the sentiment here and casually go off and say, oh, I guess we're not going to do that anymore. They're going to need to be told not to do it, and then they will respond in whatever way they will, and we'll thrash it out. But it seems to be clear that if a majority of councillors do feel that way, we need to prepare ourselves to make that as a formal instruction. The other comment I would make is that, and that's what a moratorium, it's part of what a moratorium would mean to me, is cease and desist, period, full stop, on pursuing other alternatives for seizing this piece of land. The second thing that's not clear to me, although I think Neil's wording gets at this a bit more than what was put in here, is that I mean, some councillors would like to see some other bits of information that would help them make judgments about the financial viability or whatever. They haven't seen as much material as some of the rest of us have and so forth. What I want to see is a very clearly delineated exit path from this project. And so legal, financial, et cetera. I think one of the early deliverables that will not take a lot of time, I would not think, to deal with Debbie's concern, is that we ought to be able to be shown pretty clearly, here exactly is, here are the boxes that would need to be ticked legally, whatever. Here are the financial implications in terms of people who have had outstanding commitments. There are all sorts of rumors floating around about other things that have been contracted or that people think they have been told they have obligations to this project from. I don't know the reality of any of that. Chairman Pierce doesn't want to discuss any of that in this session. He considers that a confidential matter, which implies to me that there are forward commitments of various sorts out there that we do need to be aware of and need to be reflected in the costing of any exit from this project if that ultimately is the path we want to take. And lastly, the timing, I think we've been told pretty clearly that it's not the review that is consuming the time. It's the legal reality that is creating the time. So we can moan and groan about delays and so on and so forth, but we've cooked this stew ourselves, or HBRC has cooked this stew. It finds itself in a unfortunate legal situation, which it may not be able to escape from, and that's where the time is being consumed at this point for the next 6 months, not by figuring out how much will it cost us to exit this scheme, if that's what we want to do. So I don't feel like we should be under any compulsion to cut corners or speed up or anything else. We take the time that each councillor needs to have their questions addressed, and then we move on from there. And if there needs to be clear direction in the meantime as to what we think is appropriate or inappropriate further activity by HBRC, then we should articulate that quite clearly so that they can respond in the manner they have to respond.
Clarification, do you think it is 6 months? Alison.
Sorry, the Supreme Court?
Yeah.
Well, look, the Supreme Court's notorious for taking quite some time from the point at which hearings finish and the point at which they issue a decision. In some cases, I believe that anywhere between 6 and 12 months has been the case. So, I don't know whether Danelle wants to comment. They operate to their own timetable. They don't have any statutory requirements to meet any timetable, and so it's really...
I understand we've gone for urgency, haven't we?
Correct, as I understand it.
Yes, we have applied for urgency, Chairman, but urgency is a relative concept. In the Supreme Court. It's not even it's fantastically clear what the process is, even about the application for leave. It's quite possible that they could decide the application for leave, as we understand it, on the papers, on the submissions, and kind of a desk exercise without actually having a hearing. It's entirely up to them as to whether or not they do have a hearing about the application for leave. If they decide to have a hearing, then there'll be some time between them getting the papers and the hearing and then making a decision. So as Mr Palmer has said, this could be quite a lengthy process. I think our view is that there is time for you to do your comprehensive review. And can I make two other comments, please, about scope, which might be helpful. Yeah. So one is a limitation on your scope, a sort of downwards limitation. Everything that was done before the project that was handed over to HBRC to do the 4 things we were asked to do, everything that was done up to the feasibility decision of Council in September and December of 2012, HBRC has placed legal reliance on those. That was part of the terms of taking on the project. I'd suggest you might not want to look at anything that was done before before that point. That's one possible way of limiting the scope. The second might be a bit of an expansion. So in the discussion thus far this afternoon, there has been talk of requiring us to either not proceed or effectively withdraw from the Supreme Court. There has been talk of us being required to withdraw or not proceed with the application for requiring authority, which is not actually the step of compulsory acquisition. It just gives you the power to do so. And thirdly, there has been some discussion, at least, of asking us not to take any other alternative steps to acquire the land. If you did all 3 of those things, that's tantamount to saying you wish to abandon the project. And if that's what you want to do, you should make that decision now.
Mr Chairman, if I could...
I will answer that. This council is not prepared to make that decision now. This council will tread carefully, and certainly we all have a range of different views, and that's why we need the cup of tea.
Chair, if I may, if I could just quickly respond to the issues raised by Councillor Belford with respect to process steps and an exit path from the scheme. Can I suggest that in our advice on the review process and timetable on the 30th, that we include the steps, the decision-making steps that may be likely or possible from that point on, from the conclusion of the review, because I'd make the observation that any decision to exit the scheme will be a significant decision by Council. It will require public consultation, it will require the preparation of analysis, and it will require the provision of analysis to the public around the range of issues and the options. And so we can have confidence that will be a large process required at the tail end of the review in any event. So we could start to map that out so that the full range of consequences and the timetable is more apparent to councillors on the 30th.
So weekend work in your garden is cancelled, James.
No, he needs that on a plate.
Paul, do you have a thought?
Yeah, thank you, Chair. Through you, I must say it's remarkable to hear that we've already taken steps to request to obtain a requiring authority to obtain land under the to compulsory acquire the land. I assume it's just as simple to withdraw that application and ask them to cease. There's no ramifications of doing that in terms of costs or anything like that, apart from delaying things.
So it's been in the public domain for some months now that we filed our application for a requiring authority. No, there would not be any significant cost to withdrawing, but as I just said, if you take away all the alternatives, then that's tantamount to saying the council doesn't wish to proceed with the project. And as I said, if that's the decision that councillors in the majority want to make, then you should make it before we spend another nickel.
I just want to comment to that, because that's not actually right, Chair. That's not actually right. If, hypothetically, council said, we will go with the DOC legal case, and we would support that, I'm just saying hypothetically, and we will win or lose on that, then that's a different matter. It's not tantamount to say we won't do something else beyond that to finishing this project. It's not. Not if we make that statement now.
The thing that's puzzling a number of people in the public is that we're talking about the Public Works Act. This was an act which was designed for public works, were run by the government on behalf of the community. And the puzzle here for using the Public Works Act for this project is this is a private enterprise company at the end of it, which is there to make a private profit for private investors. So how could you justify having the Public Works Act used for private profit? That's your question.
We already have a requiring authority for this project for all of the land involved in the distribution scheme. That was applied for even before the Board of Inquiry process. It was decided at that time that the requiring authority status would be limited only to the distribution scheme, to the area of the distribution scheme, for reasons which are to some degree lost in the mist of time. So standing on your hind legs about a Public Works Act for this scheme is a matter that's been long since addressed by the relevant authorities and is a matter that has been known or should have been known to all councillors for the last 3 years and was certainly known to councillors prior to that.
I just respond to that on my hind legs and say that when this came up about the application for acquiring authority, it was news to me and other councillors around this table. We were unaware of that, and you expressed surprise. So this was not known. But you, with all of the rhetoric, Mr. Pearce, you haven't answered the question. The question is not justifying what you have done before, what you're doing today, on the basis that you've done it before, if not once, 10 times, 20 times. The question is, this is a project which at its heart is going to pay a private profit to private individuals. It is a private enterprise scheme. And the question has been asked of me on a number of occasions, how can you justify the use of the Public Works Act, which works for public interests, for a private enterprise scheme?
Point of order, Mr. Chair. Dr. Pearce is not on trial here, surely.
I'm asking a question.
So do pay roads, councillor.
So let me answer the question. I'm not satisfied, frankly, Chairman, that the tone of and manner of these questions is especially civil, and I thought you were hoping to have a civil conversation. But nonetheless.
Andy, just pause. You mentioned hind legs, and you knew that would get up Rick's backside. You know,
Exactly.
so I don't think you can throw stones and then don't look. But okay, let's just settle
So
things
he's
down.
entitled to an answer
Yeah,
to his
yeah,
question.
no,
And
that's
I'll
why
give
he
it
is
to him.
entitled to that, because it is different, councillor.
And I'll give him the answer
Yeah.
to his question.
In a civil way. We'll be nice to each other, Andy.
Be nice, Andy.
So the answer is that public works include local public works, not just central government works, as I'm sure you're aware. And council-controlled authorities are entitled to use the Public Works Act for account for enterprises that they're involved in. That is the basis on which the application was made for requiring authority status over the distribution area, and it's the basis for us applying for requiring authority status over the footprint of the reservoir. They're no different from one. They're both parts of the same scheme. And it's not just private profit. There is substantial public profit.
A small question.
A public work.
Thank you. Very good.
Councillor?
A small question, Chair, and then I'm more than happy to second Councillor Curtin's recommendation. But the question is through you to Mr Palmer. The Public Works Act, can you just enlighten me here? It is challengeable, isn't it? I mean, there is room for judicial review, for example?
Certainly the Minister's decision to grant requiring authority is challengeable by way of judicial review, and the process itself, giving requiring authority to HBRC does not automatically give HBRC the right to take the land. It enables them to enter into a process, and there are a whole range of process steps, and then that is all subject to judicial review as well. As I understand it, there are a large number of network operators, if you like, electricity companies, telecommunications businesses that have been and are issued with requiring authority status because there is a public interest in network infrastructure being able to be put across public lands in the interests of efficient infrastructure. Private land, sorry.
Okay, Neil, you ready to go?
Mr Chair, yes, I do have just some minor adjustments to the recommendation 2, but I would comment, because obviously people have had latitude to do so.
Yes, that's right.
In terms of the Public Works application, I find that extraordinary that that matter not be referred back to Council for consideration in the first instance as a matter of courtesy. But furthermore, the risk and jeopardy to the Supreme Court application seen by those judges in terms of being seen to subvert their process. I would have counselled against such an action simply on a strategic point around a subsequent or consequential application. Notwithstanding that, Mr Chair, I would like to move that recommendation 2, that we agree to commission a review of key key contractual, legal, financial, economic and environmental elements, and I'll pause there to defer to my colleague Councillor Bevan. I think economic covers his point, of implementing including the impacts and consequences of implementing Plan Change 6 with and without the scheme, and withdraw from the scheme.
We have a mover for those changes. You want to second that,
Assuming we're still doing 3 and 4.
Yes.
Yeah, we're still doing 3 and 4.
Yeah, that's the whole suite.
Yeah.
I had my hand up first, Mr Chair.
Yeah, I know, and we've got a bit of, but you know, what are the couple of words? Just Paul, just put your hand down for a second where we can have a look. Is it a couple of significant words?
Sorry, the words I'm interested in having added, and again this is to 2, is agrees to commission an independent review.
Are you happy with that? Thank you for putting your hand down. I greatly appreciate that. It's back up now. Okay, so we have moved in a second with those amendments. Do you want to see those amendments? They were just words to drill down, really, and they were good. So we have moved in a second up. Do we have any discussion?
Yes, I think it's well worth as the move, Mr Chair.
Yeah.
Mr Chair, I think this step is a very important one for this new incoming council. I'm hearing what my colleagues from the last council have had to say in terms of traversing the issues and the entire suite of documentation that's gone before it, that somehow that may be irrelevant in the schemes of thing or should be limited. I've heard the issues around the delay and consequences for communities as a result of a delay. I would suggest, Mr Chair, that the happy coincidence, if you like to call it that, of the Supreme Court decision, in fact, enables us to enjoy that opportunity and also to satisfy, and I think this is the key bit, in the performance of the last council in this regard, and that's all of the council, is that while the debates have raged, the public have been excluded in some substantial manner, even though despite the claims of consultation, there are large swaths of the community that have felt disenfranchised from the process. Their feelings are that they're being excluded, that they haven't received full information. Whether that's true or not, I haven't been around the table, so I can't judge that for myself. But the conclusion I'm drawing from the community and the electors of Hawke's Bay, irrespective of the implications you may take from the vote of the constituents, is that they do want a review, they do want a pause, they do want to have a cup of tea, and they do want to see the facts on the table. That's the political reality here. No matter your current opinion, no matter your current determination to pursue or not to pursue the scheme, that is the reality that this new council has to deal with. The issue that I'm particularly interested to see as a result of the review is that let's see the implications of withdrawal. There's a loud clamour for withdrawal. I don't think any councillor around this table, no matter their prior view, is in any position to advocate for that withdrawal until they see the consequences of all the decisions made to this date, and particularly the cost implications of it. I'm not prepared to walk away from a project that's already cost the ratepayer and the taxpayer a vast sum of money in our terms. I want to see what the colour of that money looks like if and should we decide to withdraw. So, Mr. Chair, in seeking this review, I think it is timely and it's appropriate and it's what the constituents of Hawke's Bay want us to do.
Thank you, Neil. Seconder.
Well, it's all coming back to me now, Mr. Chair. That was the thing we've missed about Councillor Curtin. If you follow him in seconding something, he sucks all the information out of the discussion. You've got nothing to say. One word I wanted to say was consequence. I think that is a key part of what Councillor Curtin said, and there is consequence to a range of challenges we have in front of us, and we need to understand that. So I'm very happy to support a review.
Thank you. Other speakers? We'll start from around here. Move around. Al?
Yes, Mr. Chairman, I support the resolution as well. But what I don't support is suggestions, and I know there have only been suggestions to date, that the Council should withdraw its support for the legal initiatives and in particular the review by the Supreme Court. Questions of Public Works acquisition I guess would not sit comfortably with most of us, but any suggestion that we would withdraw from the primary vehicle that is in place to try and resolve this matter is simply sending the message that the project is finished, pull the pin, start the process of impairment and write-downs, and then consider what the Council's consequent liabilities are to resolve out of that. So, and I think also that we should be continuing to give HBRC encouragement because they've worked hard, professionally, and with great commitment against all sorts of odds to get this far, and we wouldn't have got this far without them. But the review is appropriate, and I support it in the terms laid out here.
Debbie, do you want to say something?
Thank you, Chair. As I said earlier, this review is hugely unsettling to our HBRC directors. I'd like to thank you for joining us here today, and I appreciate that you've been placed in a challenging situation that is unsettling to the rural community. And I'd like to point out that Ruataniwha isn't just about Central Hawke's Bay. There are huge implications of Plan Change 6. The plan change will roll across the other catchments within the region, and the implications will be felt widely. But Ruataniwha was a way to counter the economic effects of Plan Change 6. It also had social, environmental and economic benefits, and we must not forget that the rural community who've signed up to these water users, have made a vast investment over 35 years. They won't be the ones that will be reaping huge benefits initially. They'll be the ones that will be taking huge risks on their balance sheet and in greater debt. It is the whole of Hawke's Bay that will be benefiting. The major spin-offs will be urban. There will be the port, it will be the processors, it will be the freight operators cartage throughout the country. So just to remind you that this is an infrastructural investment on behalf of the whole region that will benefit the whole region. And as I said before, I certainly intend to be part of a constructive council that is growing and assisting Hawke's Bay in the best opportunities I can possibly support, and that will include further water storage options in the Hiratonga catchment as well.
Thank you, Debbie. Tom?
Well, certainly I support the recommendations as amended. At the same time, I'm not clear what, if anything, we've actually curtailed with respect to HBRC's activities until and unless we actually serve up a instruction of some sort. The last time we met was October 26th. That was the very day that HBRC filed its further legal brief in the matter. From my standpoint, we've triggered a substantial amount of work here, but we have not yet actually taken the step of saying, hold on, there are some things that we don't want to see happening. We're not going to take that step until the 30th at best, as I understand it. Maybe we'll come back here and see some additional information, and basically we're not putting any limitation today on how HBRC can advance this project over the next period of time. And today and previously, HBRC has made clear that it feels it has full authority to do whatever it thinks it needs to do to advance this project. We haven't changed that one iota here today, not one iota. That is still their prerogative until we instruct otherwise. I hope that we will find ourselves in a position, at least by the 30th, and I don't know what Peter is going to do at the AGM meeting with his vote, but certainly by the 30th, we have to find the resolve to say, yes, there are A, B, and C things that fine, keep spending that money, but D, E, F, no way. And we need to get to that point sooner rather than later, no later than the 30th, I would argue.
Thank you, Tom. Paul?
There are people in our community who think that this scheme is an absolute lemon. There are people in this community who think this scheme is the best thing since sliced bread. There's also any number of people in this community who just aren't sure. And that's why I'm really pleased to see that we're going to go through this review process and actually find out. So then we know what we know. And I'm really pleased as well that we're able to make contributions to the scope of the review. And in that respect, I invite any members of the public who wish to email me and let me know if they want to put anything into the review, because I think it's important that the public gets an opportunity to clear some of the concerns that they've got as well. There may be thousands of them. I don't know. I don't think so. I don't expect it. And a lot of them will probably be the same, because that's one thing that's struck me in all the conversations I've had around the scheme is everyone seems to have a particular point of view or a different reason for being uncomfortable about the scheme in general. So I'm really looking forward to seeing the outcome of this review. Thank you.
Yeah, thank you, Chair. I think it's really important to emphasise the point here that reviewing the scheme is not about whether or not water storage is a good idea. Water storage is a good idea, and I note that sitting around this table are 4 people who have been heavily embedded in horticulture, agriculture, and there's also a rural banking, ex-rural banking lender. So there are people here who completely understand the importance of water in production systems. That's not what this is about. This is about whether RWSS is a sensible investment for us and our community. And it's entirely appropriate for us to have a review after what we've been through. And just to give you a couple of examples, in the 3 years I've been sitting here, I've seen 10 moves of the date by which we would make a final decision on this, 10 of them in 3 years. That's average once every 4 months, which is loopy. If this was private industry, we'd have killed it a long time ago. So we've got the 4 conditions precedent, and in reality, it's actually 5 conditions precedent. We all know that because the 5th one, of course, is the land swap court case, which has to be resolved before this can go ahead. At various times, HBRC have come to us and asked us to agree that some of the conditions precedent are met. So far as I'm concerned, all of those are on the table for re-examination, and just as one example of that, we passed the condition precedent as to fixed time, fixed price for the building contract, that condition precedent had been met, and at the time it was met, the price was like $250 or $260 million, and the bill was 3 years, and then they came back to us 2 or 3 months ago, and they told us it was $345 million, and it was 4 years. So in what way could you argue that condition precedent had been met? Clearly it hadn't, and I imagine if there's a delay caused by the court case, those numbers will move again. So they'll have to come back to us again with a new set of numbers. So this has been a horrible, horrible process, let's be honest about it. Having said all that, we are now at the point where we've spent something like $25 million of money on it. And some of it's our ratepayers' money and some of it is government money. But we've invested a lot of time and effort into this, and it would be irresponsible to sit here today and say, no, it's over, although some people would like us to do that. The responsible thing to do, in my view, is exactly what we are doing, which is have a cup of tea, pause, review the thing, and decide whether it has a future or not, or if it does have a future, in what form. And then we can go forward with the community support and understanding of what the scheme consists of, what it can deliver to us, both environmentally and economically, and make a sensible decision as to how we proceed in a few months' time. So I will support the resolution.
Councillor Barker.
Well, just to pick up a relatively minor point on this, there's been some comment about those who have raised the issue of the Supreme Court case wanting to try and somehow torpedo this. I thought my question was quite fair and reasonable, which was, if we're going to be doing something, give me the justification for it. If it's just to be there and be supportive of DOC, well, that's okay, tell us that. If it's about this or that, I want to hear the justification. And asking for justification isn't by implication or statement saying you're against an action, so justify it. I've heard that, the justifications, and I'm okay with that. As far as the overall recommendation is about taking the time to review, I support this. We've got a community which, as elegantly put by Councillor Bailey, is that we've got some people who see it as a lemon, some people see it as the best thing since sliced bread. Well, in many ways, we've got others who think it was a lemon sandwich, I think. I'm not quite sure whether to make one way or the other. But, and out of this, there is a large number of people who are, I would describe, searching for answers and a bit bewildered about where this goes. Well, this is an opportunity for us to say to the public, whether you're in the lemon camp or the sliced bread camp or in the middle, we are going to stop and think very carefully about this. And think very carefully we must, because in this situation I can't see any decision which is absolutely the perfect decision with no implications and no consequences. Whatever we decide, there will be implications and consequences. And I'm with the person who said we need to have those clearly understood, well understood, all of them, before we make the next decision. If we decide, some people would like it to stop tomorrow, but if this process was to stop tomorrow, no one can clearly articulate to me what the absolute consequences of that decision would be. And if you can't do that, then you're not entitled to make the decision to stop it. You have to be able to tell us exactly what the implications are so that we can do this knowingly. So I think this is a good resolution. I think it's time also for us to get the public, for them to catch up and for them to be convinced about the final decision. In summing up, I'd like to make a couple of other comments. Some people have made some comments about the hard work and the commitment of the directors of HBRC. I agree with that. No question about people have been committed, they've worked hard and done a great job. Whether we all agree with what they've said or done is another matter. One cannot dispute the professionalism, the commitment, the hard work and the effort people put in, and I want to congratulate them on that. Never take that away from them. This is a big decision, and there's not many parts of New Zealand where they're looking to invest this sum of money in a project like that. This is unique. And if we don't have nerves about it, then we ain't thinking. So we've just got to be a bit more careful about it. I welcome the review and I look forward to the work of the staff and the re-examination of every detail.
Thank you, Rick. Neil, you as the mover, would you like to wrap us up?
Oh, I'd like you to, Mr. Chair.
Thank you. I agree with a lot of the comments around. I especially agree that, you know, the HBRC directors have worked hard. You've followed a vision and a dream, and I haven't always agreed, as you know. Still don't agree on quite a few points, but got to give you credit where credit's due. If I was to make a speech, and I won't want to bore you, it would be along Councillor Bevan's line. So if you listen to him, you know what I'm thinking. So we do need a cup of tea. Our community's insisting on a cup of tea. There's no negative mitigating factors in that, because we're told, you know, it looks like it's going to be 4, 5, 6 months anyway. Gives us time to review all the issues around as been manifested today, and I think that's what we need to do. We have to do that, and we have to do it in a sensible fashion, taking on Councillor Barker's point that we can't, either way we go here has serious consequences. And so we need to do it with a lot of care. That's all I have to say on the matter. So we'll move the motion. Is moved. We have a seconder, a mover and a seconder. Neil moved it. And a seconder. All those in favour of the resolutions, and it's one. We added, just added those changes. All those in favour? Aye. Against? It is carried. Thank you. And thanks for the HBRC.
Thank you, Chairman. I said at the beginning in our own report that we welcomed this review. We would do everything we could to assist it. I also said that we have pruned our expenditure back, I would say now, as far as we prudently can, and we will continue to keep it at minimum expenditure on this project while this review is being undertaken. Thank you very much.
Thank you.
And while we're angsting about Ruataniwha, Trump 60, Clinton 44.
You're joking.
Oh, that's the electoral college.
That's a long way to go yet.
It's the electoral college numbers.
Oh, electoral college.
Not that I'm looking, not that I've been looking.